So I want to, my approach to this is to explain to you the three main ways that a plaintiff files his lawsuit against a ministry in an arena or an area having to do with a child injury. All right, and that's a very generic phrase, child injury. It can be anything from a slip and fall on the playground to a sexual assault that takes place on a young person. And so it's a very wide range, and because it's a very wide range, we have to think of a very wide range of protections that we need to put in place. And so the first area, if you think about it, why should the church, why should the Christian school be responsible for an injury that is an accident? Why should the Christian school or the church be responsible for a crime that would be committed? If you think about it, let's think about the UPS driver, okay? Brown shorts, brown shirt, driving along, decides to supplement his income by robbing a bank. Okay, how many say, I think that's a crime? Yes, clearly a crime, right? But he's driving his UPS truck and he walks in with his brown shorts and his brown shirt and his brown socks and shoes, and he sticks a brown gun in the face of the teller and says, give me all your money, and holds up the bank. They hand him the money in a brown sack. He walks out of the bank and into his UPS truck and drives away. How many think that the UPS is going to be charged criminally with that bank robbery? No. Who are they looking for? They're looking for the guy who did the crime. That's how criminal law works. You look for a perpetrator. Do you think that the bank then could follow up in the criminal prosecution of the driver and file a civil lawsuit against UPS because their guy snapped one day and decided to rob the bank? The answer is actually no, because in civil litigation, there's a line that is drawn. Normally, you are automatically liable for the accidents or the negligence, is the way the law puts it, of your staff. So as a Christian school, anything an agent for your ministry does that is negligent, an accident, you are automatically responsible legally for the damages that flow from that accident. It's not any defense at all to say, well, it was an accident. We didn't mean to do it. Doesn't matter. They'll say, we didn't say you did it on purpose. If we thought you did it on purpose, we would have asked for a couple more $1 million in our lawsuit. So just saying it was an accident is no defense at all. In fact, you are automatically liable. The legal doctrine is called respondeat superior. It's the Latin phrase, and it means the responsibility of the superior, right? That entity that hired this person is automatic. You say, well, how far does that extend? Well, obviously it extends to your employees, your full-time staff. Yes, definitely applies to them. Also applies to the part-time staff. Also applies to the volunteers. You say, wait a minute, I've got, a lady that comes in and she watches recess like 3 days a week for an hour. It's a parent or whatever. Yep. Well, wait a minute, we got somebody that's coming along just as a chaperone on the field trip. Yep. Wait a minute, it's a parent, and we just ask them to keep an eye on. The minute you ask them to do something, that you kind of deputize them, you've given them responsibility, you become automatically liable for any accidents that may occur. This comes up in a lot of different contexts. The examples I gave, certainly. But even if you say, hey, brother so-and-so, could you give Charlie, who's in your neighborhood, could you give them a ride over to the, and then they get in an accident on the way over to the wherever? Yes, that's a liability now of the ministry. So be very careful about who you deputize. Now, the first way they get to the church or the school, even beyond the automatic. Understand, my entire talk is beyond the automatic. The respondeat superior, the regular accidents, the regular that's what the law actually calls it, regular negligence, ordinary negligence, and then there's the beyond ordinary negligence. You never want to be in one of those cases, all right? You weren't just normal stupid, you were extraordinarily stupid, all right? That's what they're going to be telling the jury. And so you go along and there is something beyond normal negligence, something intentional. Normally, respondeat superior ends because we say, listen, they're automatically responsible for ordinary negligence. But if this goes to the level of this person snapped and now has committed a crime, you are not automatically responsible for crimes committed by your employees. You're not. And so in order to get past that hurdle, a plaintiff has to allege one of these kinds of lawsuits. And in the law, the way a lawsuit works, we must allege that there was a duty to do something. And then we must show that that duty was violated. We call that a breach of duty. And then we must show that we were injured. And then we must show that there was a connection between the breach of duty and the injury. We call that causation. All four of those elements must be present. I make my law students memorize those. I'll leave it, you guys are much older. I'm sure you've already got them memorized. There must be duty, breach of duty, injury, and causation. All right, those are the four elements of a lawsuit. So what is the duty? What is our responsibility? That's what I'm going to show you. There are three big ones in this area. The first is the duty to screen. The duty to screen. Now, I hope that it's 2016. I've been giving this particular workshop all across America since about 1999. All right, and we've been saying this, myself and all the other attorneys at CLA and all the attorneys at the Christian Legal Society and all the attorneys at ADF and every other law group and insurance company out there has been giving this lecture. I hope that in 2016 we've got the message we have to screen the employees that come to the ministry. And that's hard because when you go through and you're doing the nursery staff, and here's Miss Hattie, who's been in the church for 63 years and who has been you've known her all your life, and you go to and say, we're going to have to do a criminal background check on you, Miss Hattie. It feels offensive. It really does, and I get it, I understand. But you have to be able to say, and this is what you tell Miss Hattie, I have to be able to say that we screened everyone. Everyone. And that's going to include you. It includes me. I had to go through this too, so I know how you feel. But don't worry, if we find something, Miss Hattie, we won't tell anyone. All right? And by the way, the people who squawk the most about this, you know why? There's something that they are a little bit concerned about. And usually it's irrelevant to you. Usually what they're embarrassed about, it was that they had a DUI 30 years ago before they came to know the Lord, or something like completely irrelevant to you. Make sure they understand what you're looking for and what you are not looking for in the screening process. So what are we looking for? Well, we have an absolute duty to screen all the children's workers. This is anyone who is going to have contact with children. Should you screen the custodian? Yes. Well, but they only come in the evening. Right, like when you have the basketball practices going on. There was a huge case in California that led to California passing new legislation, and it had to do with the janitor in a public school that kidnapped, molested, and then ultimately killed a junior high girl. And so, again, was a background check going to do anything? No, it was the classic solve the wrong problem type of legislation. You know what we should do? You know what they would have found if they had done a background check on that guy? Absolutely nothing, okay? But it was one of those we have to do something, kind of things. But it does point out that you don't know ahead of time what you don't know. And so a screening process is going to help fill in those gaps. Volunteers who have any kind of supervisory contact with children should be screened. This includes parents who are going to go on the trips. This includes anyone that's going to have contact that you delegate, you designate that they need. If you have a senior trip and they're going to go overnight and you're going to go take them to the wilds or take them somewhere else, and you have some parents who are going to go as sponsors, go ahead and get them screened. Yes?
How long does it take to get a screening? Because if I have a parent coming on a field trip and she's telling me, can I come and chaperone like a week before the field trip?
Yes, it depends on the state and it depends on the complexity. If you're doing an FBI fingerprint background check, that's a little different than if you have an online service that you've engaged. The service that we use at Maranatha is immediate. It's pretty much, it's checking the federal database, it's checking the 50 states. They all have that online now. It goes pretty quickly. And so they email you within a day, and I think it's like $16 or something like that we pay for each one. So it depends on the service that you have. Some states are slower on this than others, but that's the answer. That's the only answer. If you have a week, you should have no problem.
All these services offer legal protection just by hiring them, or you have to check that?
It's the opposite. They don't give you any legal guarantees whatsoever. They give you all kinds of disclaimers of what this service does not cover.
In the eyes of the law, it's not what they say, it's what we end up with. By using them, are we protected?
If I just choose any old service, no. I can't tell you what service, is going to satisfy the law because there isn't a law to point to. This is lawsuits, right? And so the problem with laws made by lawsuits, the good old common law, right? The problem with that is, what's the standard? Well, I'll let you know when we get to court. I'll let you know when the jury decides. What was reasonable? So I always look at it like, if I'm hiring a youth pastor, I'm going to have the highest possible level of screening that I can have. I'm going to talk to previous employers. By the way, we're going to look at what does the screening entail in just a minute. It's not just a criminal background check. That's going to be part of it, but I'm going to be checking a whole lot of other references and information as well. And of course, for our purposes, a child is anyone under 18. What are we looking for in terms of the criminal history? Well, what kind of a check am I going to conduct? It depends on the position. If this is someone who's volunteering in the nursery, then that's going to be a little bit lower level of a search that I need to do than someone I'm hiring full-time as a youth pastor. Okay, and so I usually look at the online sex offender database as the first place to look. It's free. You can plug people's names in. It's fun. You can do it with your neighbors or the guy sitting next to you. You'd be surprised how many people have the same name. It's a little scary. In Wisconsin, you can actually pull it up and it shows you the mugshot of the individual, so you know that you have the right person. By the way, every person in every mugshot looks so guilty. I mean, the minute you put next to their name offender and that picture, you're like, oh, I could see that. Oh, yeah, why didn't they know that guy's creepy, And that's a problem, isn't it, with these kinds of accusations, is that the minute it's made, it's believed. So it's difficult. But I'll check the database online for free. That's a fine, and keep record of it. That's fine in those cases. What am I looking for? Well, I'm not looking for DUI. I'm not looking for those kinds of things per se. What I'm mainly looking for, any kind of history of abuse or neglect of a child. And if I find anything along those lines in terms of a conviction or a pleading of guilty or no contest to any child offense, in my legal advice, that person should never be involved in children's ministry again. Period. Okay? You say, that's pretty harsh. What about forgiveness? What about prudence? Okay? The problem you have, and they have, is that now that this is in their past and in their record, even a false accusation against them in the future will automatically be true in the eyes of the jury, because all of this history is getting brought back up. And not only will it be true, you will be tarred and feathered as a ministry long before you're ever vindicated later on in court. And so the problem that we have with anyone with that in their past is that it's impossible to defend and say that somehow you made a reasonable decision knowing this was in their past to put them back into children's ministry. That is an unreasonable supervisory step for you to take. So you can't do it. Other criminal background results are kind of up in the air. If it didn't have to do with children, then the only thing I'm really looking for is, did they lie about it? Because when you put on the checklist or questionnaire, have you ever been convicted of a crime, and they say no, and then you find out there was a DUI conviction, now it's relevant, isn't it? Not because it was a DUI, but because they lied about it. And the lie didn't happen 30 years ago before they were saved. The lie happened last week when they filled out the form. Now I'm wondering about what else this person will lie about if it's in their best interests. So that's the only thing I'm looking for, honesty. You say, well, what about like murder, okay? Well, I actually had that case once. A ministry called me and said, we were at your workshop. We did the background checks when we got home, and lo and behold, we found out that our bus captain, they have a lot of bus routes at their church, and one of our best bus captains has been with us for 20 years. But about 6 months before he came to us, 20 years ago, he had gotten out of prison for murder. And he had done like 11 years in jail for murder because, and they didn't know it. And then for 20 years he was a bus captain, no problem at all. And I said, well, what's the story? You know, did you talk to him? Yeah, we talked to him. Here's the story. He was in a bar fight, and a lot of people were fighting, and he cracked somebody over the head or something, and they died, and he got charged with murder because of this whole fight, and he spent 11 years in jail, and now he's out, but then he got saved in jail, and God changed his life, and he's just been incredible since then. I said, well, I just have one follow-up question. Was the person he killed, you know what I'm going to ask him? A child. And they said, well, no, he was in a bar. You know, it wasn't a child. I said, okay. Then as long as he wasn't lying about it, and as long as it wasn't a child offense, and as long as you as a ministry know about it and make a reasonable business judgment that he is not that person anymore, he's been reformed. I can't believe I'm saying it as a lawyer, but I guess I'm okay with that. And they were relieved. They were relieved. And of course, I had the 20-year track record of no problem to lean on as well, right? If they'd asked me that at the time, I don't know if I would have said the same thing. So, but it kind of illustrates that what we're really looking for here is child offenses, all right? We're not looking for those other things people might be embarrassed about. That's really kind of irrelevant. Knowing and make a reasonable and documented decision can be defended. Not knowing can't. You saying I didn't know can't be defended. Even if I'm sitting there saying as your lawyer, but even if they had known this would have been, it's not going to fly. The jury's going to look at you and go, they don't care about kids. That's the conclusion that they reach. So we've got to make sure we have it. What is the screening process? It doesn't stop with the criminal background check. You want to have even a volunteer should sign an agreement. It is a privilege to work in children's ministry. It is a privilege. It is not for everyone. We know that, right? It is not for everyone. And so people need to understand that you will vet them. You will screen. Ask the right questions. I won't get into this too much, but you have to ask the questions that matter to you. And on the stand, when they sit there and put you on the stand and say, okay, administrator, okay, pastor, did you know that this person who's being accused now was addicted to child pornography? No. What? Yeah, they'll allege it. It might not even be true. They're asking hypotheticals. But they'll say, did you know that? And they'll make you go down a long list of questions like that, which you will say, absolutely not. And they'll say, well, if you had known, what would have been the consequence? Well, I would have never hired him. We would never have somebody like that in our ministry. And you get upset. You get angry even. I've seen it happen. And then they do the Columbo thing. Oh, okay. Well, and they're flipping through their legal pad. I guess I just have one more question then. If it would matter to you so much that you wouldn't have hired that person and would never have somebody at your ministry that was like that, did you ask? And when you say no, they say, oh, you really cared then. You really cared so much about that. You say, well, we just assume. You can't assume anymore. You've got to ask the right question. So having a checklist of things where even some of those embarrassing type things to ask, it will help you in this process. Check references when that's appropriate, and even interviewing the candidates face to face is a part of the screening process. Yes, sir?
Do you have an example of a volunteer agreement that
Sure.
you think is a...
Yes, and I'd be happy. I have all of these kinds of things I'm recommending. I have examples and samples I'd be glad to send you. Just see me afterwards, and I'll give you my card. You can email me and let me know what you need. Yes?
We had a case where a parent was investigated by the DCFS, but it turned out it was false. What happens after that? Can they...
Unfounded accusations where the due process has gone through, that's not, I don't care about that. I don't care about it. As long as you know about it and have made your reasonable judgment.
How many times, how often do you do background checks?
Well, definitely on the way in. I mean, I'm happy when you do it on the way in. Some states have what they call a subscription service, which will actually give you an arrest notification if you give them a list of names. That's nice, but there's only a handful of states that give us that service. And then other services, you keep your staff names on file, and you can ask for an annual recheck or on a basis like that. I don't have a specific recommendation on that. You need to talk to your insurance company about that. That's the best resource to talk to about what their expectations would be for you in your area. Yes?
What about someone, because usually, your church and your schools, ministry is one. What about a sex offender who is attending church that might come over to a school event?
So that's a big issue, because if you have someone now that is a sex offender, the public policy type question would be, should this person be allowed to attend our church? And you say, well, boy, we hate to close the door. The doors are open to sinners of all kinds, and what these people need, according to, and what all of us need, is to be in church. And this is in their past and in their background. By the way, I can just about promise you, you have people attending your church that have a offense in their background. And you need to be thinking about that in terms of the checks that need to be made and so forth. When someone comes to your attention that this is the case, just as a church attendee or member, then my practice is to have the pastor and maybe a deacon or two sit down with this individual and explain to them the limitations and expectations that you have for them. That they are not to be the candy guy. They're not to be the hugs guy. Okay? You have these people in your church, they're different roles that they play. I'm the candy guy, I get all the kids come over. They're to come, they're not to go into any part of the building where the children's ministry is, that they're not to go near the nursery, that they're not, and you explain to them, brother, it's not because I don't trust you anymore, although I don't trust you anymore. It's not because of that I think you're going to do something. It's for your protection, for our protection, and most of all, for the children's protection. We're not going to put you in a situation that would be tempting. The recidivism rates on child abuse are off the charts, okay? Way too high to ignore. And the grace of God notwithstanding, okay, we're not going to play with fire. And so we have those expectations. And then in our church, what we do is we have given that list of names to the deacons, to the ushers, and they enforce those expectations. And if someone violates that and begins to get loose with that, then their privilege of attendance is revoked. And we say, it is not a legal right for you to be here in the public services. And it can get to that level. I don't want to just ban people, but if by their behavior they show us that they're unwilling to observe those boundaries, then they've brought that consequence on themselves. It's the only reasonable approach that we can take, in my view. Okay? All right, let's look at the next one. The next one is the duty to supervise. They will say that their child was injured because you breached the duty to supervise. Now, I'm just going to put it this way. We have an absolute duty not to let the children get hurt. I mean, obviously not to hurt the children, but it goes a little further than that, not to let them get hurt while we are on the clock. Now, I use that terminology because it's more than just what you think. It's more than just 8:15 to 3:15 when the bells ring, okay, on the school day. It's from the moment they're dropped off, maybe even before you take mental note of the fact that they've been dropped off, but from the moment they're dropped off until the moment they are picked up by the right person. And I say it that way because if they're picked up by the wrong person, you're still on the clock and responsible for that. So we have to have good policies, number one, that make it clear when we are on the clock by telling parents when they can let their kids off. At my school, it's from 7:45 in the morning is the earliest you can drop your kids off. There have been a couple of days, I can remember when my boys were small, where I had to be somewhere at 7:45, and so I dropped them off outside the door, and I watched because they went up to the door and they pulled it, and it was locked. And I said, well, you dressed warm for a reason, kid. I'm out of here. And I'm just sort of trusting that there was school that day and that it's 7:45. Now, when I left them there, that was on me. And if something had happened before the doors opened, then that was on me as a parent, wasn't it? Because the school did not accept them into their responsibility until 7:45, and that was very clear in my mind. But I was okay with that risk. It was like 7:42, okay? And they were 5th and 6th type, grade boys, so what could possibly go wrong? And so when they opened the doors, that's when they accepted responsibility. When I pick them up at the end of the day, that's when I take it back. Anything happens in between, you can pretty much just count on the fact that your insurance is going to pay for that injury, all right, no matter how it happens. So let me give you just a few quick rules here. You cannot supervise what you cannot see. Do we understand that? You cannot supervise what you cannot see. That means there are probably areas of the facility that need to be reviewed. One of the worst cases I had for child-on-child abuse was a sexual situation. Took place between 2 second graders. I couldn't believe it. 2 second graders that found a little hideout between the air conditioner, air handlers out on the grounds. And the playground monitor said, I can see the whole playground except for that one little blind spot between the 2 air handlers. And that's exactly where the kids went and found themselves. Now listen, they know what your blind spots are. Do you? Okay, do you? So your people need to know where the vulnerabilities are. Classrooms, when they're not in use, things like that. Look for potential unsafe conditions. And then let me give you this last one here. Friends don't supervise friends. So I'm all for being friendly. You know, you have that new teacher that comes in fresh out of college at Maranatha, and they come in and they're happy and they want to be friends with all the kids. That's great, but we need to be a little careful about that because there needs to be what the prison guards call professional distance, right? The respect. I really don't like the whole first name basis trend that's going on in education right now. Hey Eddie, or whatever. No, I don't like that, okay? Why? Because it's sort of breaking down those barriers that need to be there. It's everything that goes into that. It's how we dress, how we carry ourselves, how we approach the children physically, and it's not, hey, I'm here today, everybody, big group hug, and we're buddies, right? Because I can't be the authority in the room if we're all peers, right? And that's a problem. And I think younger teachers in particular generally struggle with this in the beginning, and that's where a lot of the problems occur. That's where a lot of the problems occur, okay? All right. So some clear policies and training. Once you've done the training, if a staff member refuses to follow the rules on this, I'm sorry, but you must dismiss them. I was at a ministry one time giving this kind of training, and I was told, well, we have this study hall monitor. She used to be a really good teacher, but she sleeps through all the study halls. And God bless her, she just is, I guess, not getting the rest she needs at home. And so she comes to work to sleep. And I'm saying, I'm sorry, that's not supervision. Well, she just refuses to do any of this nonsense, you know, this that we do with the training. And I say, well, guess what? You've got a choice to make, because now you know about it. So it was her problem, but now you know about it. It's your problem. Isn't that fun how leadership works? I didn't cause this issue, but now I have to deal with it. And then I put it this way, nobody is better than the wrong somebody. And you say, but what about, I mean, I deal with these all the time. Well, what are we going to do? How will we ever get somebody new to handle this? And they're so good over here, but with this, it's unbelievable. I'm sorry, but if that's an issue that's putting kids in danger, you got to let that person go. We're better off with nobody than the wrong somebody. And then it's the appropriate touch rule. I can't call it the no touch rule, although that's my legal preference, because there are times when it is appropriate to touch children. I haven't figured out yet how to change a baby's diaper without making physical contact, all right? If I could, I'd probably make billions, you know, just from dads alone. But
Lay the diaper.
yeah, that's right. But there are times when it is appropriate. If they're fighting, you've got to break up the fight. But there's an appropriate time for that, and then it ends. And what happens is many times, especially as men, the adrenaline kicks in, you grab the two kids, you rip them apart, you know, and then you grab this kid, what are you doing? Why are you fighting? Next thing you know, you got him propped up against the locker and you're poking him in the chest and you got to grab a hold of the arm. We're going down to the office and you're marching. Well, that's a problem, because what started as an appropriate touch became an assault by you, all right? And so we have to know where those lines are. Hugs. You know, hugs are a hard one. And ladies, frankly, I have never had a case with a lady and a hug being a problem. So, you know, unhyper yourselves when I say this. But we can't be hugging the kids all the time. Guys especially. Why? Because especially a front-to-front hug. It's majorly problematic. The children are not tall. In my experience, children are not tall. All right? And so they come at you. And sometimes kids are like a hug-seeking missile, right? I mean, they cannot be denied. And so even without encouragement, they may be upon you without a moment's notice. And so what can we do when that's the case? Well, number one, getting on their level helps. So I will usually say, go down on one knee, and that's now greatly helped the situation, right? We're no longer standing at different levels. The second thing, the great thing, is the side hug, you know, and I'd much rather, I'll defend you all day long if it was a side hug. If it's a front-to-front embrace with you standing up and them being short, we got a problem. And here's the other issue. Here's the other issue, and this is frankly the bigger deal. The guy that's known as the hugger, people believe it when an accusation is made against that person. And your reputation is toast at that point. And so it's very difficult to defend when someone is known to be very physical and then an accusation is made. So someone who is known to be very appropriate and very careful with that kind of thing and observes this, I can defend you, all right? So that's what we're talking about there. Now, the third one is the duty to respond, the duty to respond. And with this, we talk about our reporting obligations. Number one, we have a duty to separate. You need to tell your staff ahead of time so that they understand this and don't feel like you are attacking them and believing their accuser. You need to tell them ahead of time that if an accusation is made, even before you investigate, you're probably going to separate them from the situation. That might mean some kind of an administrative leave that you put them on while you're looking into it. If you tell them that ahead of time, it will greatly help when and if you ever have to do that. It's still going to hurt. They're still going to feel like you suspect them and how can you not believe me and all the hurt feelings. But at least they'll understand it's policy, it's practice, it's what we have to do. Blame the lawyers. That's fine. We're good for being blamed, all right? So no problem with that. But you've got to separate them. The situation only gets worse when you leave them in contact with the people that are making the accusations. The thing starts to snowball. They think they're helping by talking to Johnny about it, and it's not helping, okay? We need to let other people talk to Johnny, not the person who's been accused. We have a duty to investigate. Every allegation of a child being harmed should be investigated, every one, even if it's a little bit bizarre. I actually had a case once where a kid said that he was abducted by aliens and that they did unbelievable things to him. And they poo-pooed it and they said, oh, give me a break, you weren't abducted by aliens. And that's true, he wasn't abducted by aliens. But in his childlike mind, he was trying to tell them that an uncle that had been visiting his house had been abusing him. He was using different language, but he was trying to tell a real story. And so once the school figured out, you know, there's too much realism to what these aliens have done to this young man, we need to look at this a little bit more carefully. Most of what you hear will probably not be allegations against your staff members. Most of what you deal with in terms of the responding will be things that are happening at home or other places outside of the school. And so that's why we ask the question, do we have to report? Now, every single state has a child abuse reporting law. And these laws exist because child abuse is a very real thing. In 1974, that's when most of these laws came into effect based on a federal statute that incentivized states to put these into place. That year, there were 60,000 abuse reports filed across the country. Just 60,000. Now, flash forward to the year 2000, that had risen to 2.8 million reports across the country. Flash forward from there to 2012, it's 3.4 million reports across the country. Now, many of those reports deal with multiple children being involved. That involves 6.2 million children that were impacted by those reports. That's 65,000 reports a week. So think of it. We went from 60,000 in 1974, the whole year, to 65,000 reports a week in 2012, which is the most recent report. We have people here from Illinois. In the state of Illinois alone, a child dies from abuse or neglect every 36 hours, just in the one state. Children served by children's ministries are certainly not exempt. And so we have to understand that the purpose for these reporting statutes is to protect children that are in vulnerable situations. So, what are the requirements? We have it here at the convention: Illinois, Indiana, Minnesota, Ohio, and Wisconsin. Any other states? I didn't look you up. All right. What is it? Oh, Michigan. Yeah, I did look up Michigan. I actually do have Michigan on here. I must have run out of room in the title. All right. The child abuse reporting statutes require certain people to report known or suspected child abuse. Every Christian school worker should assume, for the sake of reporting, that they are a mandatory reporter. I've looked up all of these states, and each one of them, it says anyone in children's work. It's very generic. It's not just talking about employees, so you need to do the training for everyone. So what is required? Well, let's look at Illinois. Any mandatory reporter having reasonable cause to believe that a child known to them in their professional or official capacity may be abused or neglected shall immediately report. Oh, by the way, Illinois requires training within 1 year of hire and retraining every 5 years. Did you know that? Do you do that? That's in the law. Indiana, any individual who has reason to believe that a child is a victim of child abuse or neglect shall make a report as required by this article. Indiana is an everyone is a reporter state. That's rare, but Indiana is everybody. Okay, so that obviously includes children's ministry workers. Michigan, any mandatory reporter who has reasonable cause to suspect child abuse or neglect shall make an immediate report to centralized intake by telephone through the online reporting system. Within 72 hours, you must make a written follow-up report. Did you know that? There's a requirement. Notice the time frames. Immediate, and then again, follow up within 72 hours. Minnesota, mandatory reporter who knows or has reason to believe a child is being neglected or physically or sexually abused, or has been neglected or physically, sexually abused within the preceding 3 years. I like that. There's a time limit on this one. That's the only state with a time limit, okay? Nobody else has that. So we deal with it at Maranatha. Somebody is in college now, and they talk about something happened, 10 years ago. It creates a big question. But in Minnesota, only just the last 3 years. And then again, the time frame shall immediately report the information to the local welfare agency, the police department, county sheriff, tribal social services agency, or tribal police department. Ohio, no mandatory reporter who is acting in official or professional capacity and knows or has reasonable cause to suspect, based on facts that would cause a reasonable person in a similar position to suspect, that a child under the age of 18 years has suffered or faces a threat of suffering any physical or mental, and then it gets into the abuse definition, shall immediately report that knowledge or reasonable cause to suspect to the entity or person specified in this division. Ohio could do some cleanup on this. By the way, this is updated. I was getting excited because I went and researched all these to update for this session, and I found out that Ohio last session changed its child abuse statute. And it is taking effect October 12th, all right? 5 days from now. And I was, oh, sweet, this is breaking news, Well, what did they change? Well, what they changed was they replaced references in the revised code to the old term mental retardation and its derivatives to intellectual disabilities, all right? That was the only thing they changed, so not much of a difference, all right? But in terms of the child abuse reporting requirement, that's what's required. Wisconsin, any of the following persons who has reasonable cause to suspect that a child seen by the person in the course of professional duties has been abused or neglected, blah, 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 shall report as provided by law. So, what do they all have in common? If you have any reason to suspect that a child is or may be, then we have a problem. Who are the mandatory reporters? All school personnel. What are the definitions? Abuse is a physical injury inflicted on a child by other than accidental means. You say, well, it was a spanking. Does abuse, or is a spanking abuse? The answer is no. It is constitutionally protected. There is no state that defines spanking on its own to be abuse, unless it causes a physical injury. And that's where we have a problem, because physical injury can include, obviously, broken bones, cuts, but it can also include bruising. And so we have an issue there if there was an accident. Now let's say that the story is they broke their knuckle because dad was giving them a spanking and they put their hand back there. Well, notice, other than accidental means, I would say that was an accident. That was not what was intended, right? But we would all say, while we might agree that parents have a right to spank, we would all say beating a child with a stick or a 2x4, it crosses the line, right? So where is the line? It's difficult. It can be difficult. But the law draws the line at when an injury occurs, all right? And that could be a session for another day, but that is where this falls out. Neglect is more difficult. Neglect usually takes place over time, where you're noticing that this person, this child, is losing weight, they're not being fed, they have a medical condition that's not being cared for. Something like that. That can be neglect. And you need to get some training for your staff on exactly how to spot that and what is needed there. And of course, a child is any person under the age of 18. So when do we report? Every one of these statutes says immediately. And legally, immediately is like 24 hours, right? So sometime within 24 hours is what we're looking for. Actual knowledge of abuse is not required. This is where we get in trouble. Well, I don't have proof. Was there any one of those that I read that said you needed proof? What did it say? Reason to suspect. Well, how percentage sure do you have to be to have reasonable, cause to suspect? I'm thinking like 10, 15%. That's it. You're not the prosecutor. Proof of abuse is not required. Notice, immediately report. Actual knowledge, not required. Proof, not required. How do I report? Report it. Usually there's a child abuse hotline. If you don't, my recommendation is work with the local police department. They've seen other crimes. They have a more reasonable approach to this than do the social workers generally. And so develop a relationship with the police department so you can call them up. In fact, it may be, and I'll end with this, it may be that you do what I've done at least 5 times, and that is we call and say, I don't even know if this is something I should report. And you tell them a little bit about the story, the situation, sort of without any names, and let them tell you if they think you should report it or not. In only one of those cases did they tell me, you know what, I think you're right, that's really not something you need to report. Most of the time, they say, go ahead, give us the information. What will surprise you to know is, what you know is the tip of the iceberg. And today's actions are going to be judged in the light of tomorrow's information. And what comes out tomorrow is going to make today's decision look awfully bad if that kid was being injured and you said nothing. So let's make sure that we have these duties covered correctly. The duty to screen, the duty to supervise, and the duty to respond.